The arraignment will be continued until October 19th. Mr. Masterson, you have the right to a speedy arraignment. You could be arraigned in this case today. Do you understand that right and agree as your attorney is requesting that your arraignment be continued until October 19th?
Yes, sir.
Counsel join?
Yes, sir.
The court will set the following briefing schedule. The people's opposition is due no later than October 2nd. Any defense reply is due no later than October 9th. And any reply filed by the people to the defense reply is due no later than October 15th. The demurrer will be litigated on October 19th. The people have provided the court with a proposed protective order listing the following complaining witnesses. Mr. Masterson, please listen carefully. You're going to be served with a copy of this order now. You must not harass, strike, threaten, assault, follow, stalk, molest, destroy or damage personal or real property, disturb the peace, keep under surveillance, or block movements of the protected party. You must not own, possess, buy, or try to buy, receive or try to receive, or otherwise obtain a firearm or ammunition. You must surrender to local law enforcement or sell to a licensed gun dealer any firearm owned by you or subject to your immediate possession or control within 24 hours, and show the court that you have complied within 48 hours. You must not attempt to or actually prevent or dissuade any victim or witness from attending a hearing or testifying or making a report to any law enforcement agency or person. You must take no action to obtain the address or location of the protected persons or their family members, caretakers, or guardians. You must have no personal, electronic, telephonic, or written contact with them. Have no contact with them through a third party except your attorney. Stay 100 yards away from them, and they may record any prohibited communications made by you. The court is also in receipt of a waiver of defendant's personal appearance pursuant to Penal Code Section 977B. The form appears to have been signed today by Mr. Masterson. Mr. Masterson, did you sign this form, sir?
Yes, sir.
Prior to signing the form, did you discuss it in detail with your attorneys and did they answer your questions? Do you understand that you have the right to be present at every stage of litigation in this case and agree that when the court permits, your attorneys may appear in court on your behalf without you present?
Yes, sir.
Do you also understand that you must be present anytime the court orders you to be present for any substantive hearing, for any preliminary hearing, for any trial, and for any disposition in this matter?
Yes, sir.
The 977B waiver form has been lodged and is accepted. Counsel, is it your intention to appear pursuant to 977B at the demurrer hearing?
Yes, sir.
Mr. Masterson, your attorneys have filed a demurrer in this case. I have just set a briefing schedule. That demurrer will be litigated very likely at the next court date. Do you understand that you have the absolute right to be present at that hearing and give up that right and agree that your attorneys can appear on your behalf?
Yes, sir.
And the 977B has been lodged and is formally accepted. That is pursuant to the emergency court rules adopted by this court in early April. One moment. And let me ask, counsel, do you join in that request to appear pursuant to 977B for purposes of the demurrer hearing?
Yes, sir.
Yes, sir.
Turning to the protective order that has been, the request for a protective order that has been filed by the defense, the court has reviewed it. Have the people received a copy of this order request?
People have received a draft copy of it previously, and today we received a copy of the order that was filed in the court.
Are the people prepared to proceed in oral argument on this motion at this time?
Yes.
All right, let me turn to the defense. It is the defense motion. Is there anything that you would like to add to your moving papers at this time, counsel?
No, Your Honor, I rest on my papers.
People?
Your Honor, people are opposed to this order as it's currently constructed. First of all, it is the people's interest, certainly, to avoid any kind of a dissemination of evidentiary matter that would have a reasonable likelihood of prejudicing this case. We obviously share that concern and that interest with the defense. However, this protective order, as it's currently drafted, as it's constructed, is objectionable. First of all, it's overbroad. It's grossly overbroad. And I think it asks this court to exercise jurisdiction over parties, third parties, that is beyond the scope of the court's jurisdiction, respectfully. In addition to that, as it's written, it's foreseen that this is going to require numerous hearings. That's going to expend judicial resources when the time when judicial resources are already short. Merely on the application of the order itself, and under various circumstances, because defense counsel has not yet reviewed the discovery. They've been turned over a copy of that today. But as it stands now, there is a lot of evidence that is in third parties' possession, and it would be, as this document is drafted, it would be very, very difficult to kind of exercise any kind of court order over the documents as they are. So it needs to be more narrowly tailored. I think as it's written, it's grossly overbroad, and again, I think also premature, since counsel has not yet reviewed the evidence. They don't know what it's contained and what their order is asking to limit in terms of the disclosure.
Your Honor, just for the record, we did send a copy. The draft is the same copy that we submitted today, just without the word draft on it, to Mr. Mueller on September 4th. So we had hoped that any issues could have been worked out prior to today's court date, if there had been any issues with overbroadness. We did not receive any response back, other than that it had been received. Your Honor, in response to what Mr. Mueller did say about this being outside of the scope of the court's authority of the people to restrain, there is case law that the court does have jurisdiction over multiple people, including court staff, law enforcement officers, and witnesses that would potentially appear in your court. So for that reason, we disagree.
Anything further from the defense at this time?
No, Your Honor.
Mr. Masterson, through his attorneys, has requested an order to prevent dissemination of information concerning this case, and the defense has specifically requested an order constraining all attorneys, parties, investigators, witnesses, court officials, and law enforcement officials from disclosing discovery materials to the press or placed on social media in any way. In support of its motion, the defense has argued that such an order is necessary, quote, because there is a reasonable likelihood that dissemination of information concerning the case would make it difficult to impanel an impartial jury and would tend to prevent a fair trial for Mr. Masterson. The defense has urged this court to review and adopt the reasonable likelihood test as set forth in Younger v. Smith, that's 30 Cal 3rd 138, which supports the issuance of such an order when there is a reasonable likelihood that information about the case would make it difficult to impanel an impartial jury or prejudice the defendant's ability to receive a fair trial. The court will also note that it has reviewed the clear and present danger test as set forth in Near v. Minnesota, 283 U.S. 697, in conducting this analysis. Under either standard, such orders are considered an extraordinary remedy and one that must be relied upon only when a sufficient showing has been made. At this stage of litigation, based on the representations of defense counsel and the case law set forth in the defense moving papers, the court does not find that a sufficient showing has been made to support such an extraordinary remedy, and therefore the request for a protective order at this stage is denied. It's denied without prejudice. Turning to the question of bond, it appears that Mr. Masterson has posted bond in the schedule amount of $3,300,000. Would the people like to be heard?
No, Your Honor. People would obviously seek to have that stand per schedule.
Bond is to stand. Is there anything further from the defense at this time?
No, Your Honor.
Anything further from the people?
No, Your Honor.
All right, have a good day, everyone. We'll see you back on October 19th.
Thank you.
Thank you.
Thank you.